Are you sure?
Here's the 30-second lesson on what legends know. Never ask a bride why she's getting married. Don't wear a skirt on a windy day. Deodorant is not a shower. Don't sniff chili flakes. And don't forget, saving is not investing. Legends don't just save, they invest in mutual funds. Mutual fund investments are subject to market risks. Read all scheme-related documents carefully.
In our already polarized and polarizing, rapidly further polarizing debate in the lead-up to the election campaign of 2024, the small state of Uttarakhand has made the first move. They've made the first move on what is called as Uniform Civil Code. Now, we saw already something big has happened, say on Hindutva side, with the consecration of the Ram temple in Ayodhya. Now, BJP, because this has been one of their main planks, the RSS's main planks also, Article 370, Ram temple, and also Uniform Civil Code. Now, they've made the first move on this with Uttarakhand government placing on the floor of the House the UCC Bill 2024, the Uttarakhand Uniform Civil Code Bill. That's the name. They haven't used any camouflage for it. The Uttarakhand Uniform Civil Code Bill 2024. They have a majority in the House. It will be voted tomorrow, and chances are it will be passed. Now, that said, we have to look at many aspects of it. I have talked about this twice in the past, and I will share both the links with you. Once about Uttarakhand's original draft, and once also about the larger debate on where the BJP and RSS are coming from on this, because their concerns seem to be purely demographic. Their concerns don't seem to be, at least that's the pretense or the argument. It's not so much about why does somebody have more than one wife. It is more about some people or some section of Indian population producing more babies. So whereby a demographic balance is getting altered in the country. So all of this, there is ideology to this. There is also some moral argument to this, but deep down, there is a demographic concern to this. We will also talk about how genuine that concern is. So what we'll do is, because it's a complex issue, it's also an issue about which I have spoken a couple of times. I've also used the Pakistani comparison. For example, in Pakistan, it was in 1961 that Field Marshal Ayub Khan, as a dictator, he just produced executive orders to do away with triple talaq, automatical triple talaq, and also polygamy, automatic polygamy in 1961. And so many governments have come in after that, including Ziaul Haq's Nizam-e-Mustafa and also Taliban Khan's government. They haven't altered any of that. They've been minor alterations. So there's always been an argument in India from the BJP RSS side that if the Pakistanis could change it, if most Islamic countries have changed it, how come India cannot change it? The counter argument was that Indian constitution allows every community, particularly minorities, to follow their own personal laws and their own ways of life, and the state should not interfere. In this situation, this new law has been presented. So what I'm doing is, instead of making you suffer my monologue for 25-30 minutes, because it's a complex issue, I've got three of my stellar colleagues. Each one knows a lot more about this issue than me. So we are going to be listening to all of them. To my left is Neelam Pandey, who's one of the senior members of our political reporting staff. She's looking at the political aspect of this, because deep down, it is actually, why just deep down? This is on the face of it all politics. So she'll explain the politics. She's also done the main story on this today. So we'll share a link. To my right, Bhadra Sinha, who heads our legal and judicial team. She will give us a larger idea of what might happen now. How will the legal community react? What can be challenged judicially? What is the constitutional position? And Apoorva Mandhani, who you know well, she's my partner in crime often enough, once a week with Headlines Ke Piche, and she features also when we talk about complex legal constitutional issues. I have her, she will explain also many of the nuances of the new law. That said, let me get a little bit of politics out of the way before I take it to the three participants. That larger political point is that, as with the Ram temple, this leaves the opposition in a bit of a bind. In fact, in more than a bit of a bind. Because on Ram temple also, they could never oppose the Ram temple, because they had welcomed the Supreme Court order, and as far as the major opposition parties are concerned, none had said that they don't want the building of the temple. So they had got caught. Now that the BJP and RSS had built it, they didn't know what to say. So to that extent, that argument was won by the BJP and RSS. Or at least the other side were not able to counter it, except by saying that the Prime Minister made it a political event at which he promoted himself, or a political event to promote him. Similarly, some similar politics will apply to this decision as well, because which party is going to say polygamy is okay? Which party is going to say not having a common minimum age for women to marry is okay? Which party is going to say that acceptance of live-in relationships is not okay? There's a nuance there that these two will explain to you. Or which party is going to say that in succession law, the same law should not apply across faiths? Why should different faiths have different succession laws? And similarly, the opposition on principle will find it difficult to argue that what this law says on maintenance. And this goes right back to the Shah Bano case, because Shah Bano case, where the Congress party's downward slide started, that was a case where a rich lawyer's wife had gone to court seeking more alimony beyond her meher. The court had granted it. She had won her case in the Supreme Court, but under pressure from the ulema, Rajiv Gandhi amended the law and thereby rendered the Supreme Court judgment infructuous. This law, in fact, says that whatever your meher, in the case of a Muslim woman, doesn't mention it like that, but for any marriage, whatever your other agreements, you can now go to court and claim alimony or maintenance. So that is my political summary before we get started. Now, Bhadra, if you can tell us, how will this fundamentally change the law of marriage succession in India?
See, so as of now, we have different laws, different personal laws governing in different communities in India. And the only codified law is the Hindu Marriage Act, which actually governs the Hindu community. And over there's a proper procedure which is laid out. You have courts to hear cases of, divorce and maintenance. But for the other, particularly the Muslim community, you don't have a very structured format. What UCC actually does it provides a structured format for all the communities. It basically says at what age you can marry. You have a uniform age. It also lays down the conditions.
Until what age you cannot marry.
Okay, yes, let's put it like that. Until what age you cannot marry. It lays down conditions for a marriage, and one of the conditions very clearly says that you can only marry if you do not have a spouse. Means you have to be unmarried to get married, which is not defined in any other law except for the Hindu Marriage Act. Then you also have a proper procedure laid out for maintenance, which so far is only there again in the Hindu Marriage Act, particularly for interim maintenance, in the sense when a divorce proceeding is going on, it is pending, or so what is how you can get the interim maintenance, from whom you can get the interim maintenance. So all these, the procedures have been outlined very systematically, permitting women or men of all the communities to get a redressal as well. Apart from that, I think the most important facet of UCC in Uttarakhand is the recognition of a live-in relationship. Of course, there is something critical about it in the sense that it is actually making registration of live-in relationships mandatory, which I think is a very tricky area, and it could open up for a legal challenge. And interestingly, when there is a termination of the living relationship, then also you have to go and inform the authorities and get it registered.
So, Neelam, that's part of your story. So, explain this a little bit more.
Yes. So, this is something we had also reported in November 2022. So, what is interesting is that, as Bhadra pointed out, it is not only about registering your live-in relationship, but at the same time, if you fail to do so, you can be fined as well as you can be sent to jail. At the same time, there's a dichotomy. While they are saying that the legal age for a woman is 18 years and for a man 21 for marriage, as far as live-in relationship is concerned, if someone is below the age of 21 and they want to enter into a relationship, live-in relationship, man or woman, anyone who is below the age of 21, in such a case, the registrar will have to inform the guardian or the parents about it. And at the same time, the local police will also be informed about it. At the same time, it also says that the registrar can also refuse to register a live-in relationship if he feels that there are certain criteria that have been laid out, if he feels that the consent was taken under coercion. At the same time, if it says that it challenges the morality or the policy of that particular society. It also says that there could be any other reason which the registrar may have, and you can challenge it, but he can definitely say, no, this statement is not getting registered.
So this amounts to, if I may ask you, this amounts to bringing the state into a personal relationship.
Yes, and this is what the opposition today, as you pointed out, that while the opposition might not be able to challenge other aspects of the bill,
like banning of polygamy or
bigamy or instant talaq or the empowering women, but at the same time they are saying that in a way the government is entering the bedroom of people. And how legitimate is that? Because live-in relationship is something that has become very common. So as far as youngsters are concerned, they have been posting on the social media that this is something which they are not happy about.
Apoorva, how concerned are you about this, and how do you think will this play out? And is there any legal precedent about live-in relationships or the rights of live-in couples?
Right. So the thing is, live-in relationships were recognized by the Supreme Court, but under a law except for the Domestic Violence Act, no other law really regulated them per se or applied to them as such. It was only the Supreme Court. Now with this registration, it does seem like, at least on the face of it, that this may, if at all challenged, privacy would be a big argument that comes in here, because live-in relationship hasn't even, just small pointers, it hasn't been defined under the code. So how do you define that two people are actually in a live-in relationship? What sort of inquiry will the registrar do into whether he should be certifying giving a certificate of live-in relationship or not? Then the ambiguity around the age is a factor. Another important factor, and I've done a small story on it also as well, is that this part on live-in relationships uses the word partners, which I felt was interesting, because the part on marriage says marriage between man and woman. But this part specifically uses the word partners, which makes me think that maybe this could apply to live-in registration and live-in relationship for same-sex couples, but that's another ambiguity that could come in. So all in all, it needs more refining, if at all. And like Bhadra also said, this could definitely lead to a potential challenge in the Supreme Court.
And just to add to that, as far as live-in relationship is concerned, for the first time, legal backing has been given to women who can then claim maintenance for the first time.
Yes.
And also children born out of live-in relationship will also be called legitimate.
So then then how is a living relationship different from a marriage?
Yes, right. That is the question that is being asked. That why the need for this?
I guess the only difference that I could see was because they have listed down conditions also. There are conditions under which
for a marriage,
for a live-in relationship as well. So both persons again, both partners need to be major, they can't be minor, which is similar to marriage again. Yes. They can't be within prohibited degrees of relationship also, which is again the same thing
in the marriage.
Yes. So these are some of the conditions that have been laid down. The only difference was that termination felt much easier. So it just says that if you terminate a live-in relationship, you just have to give a statement to the registrar. And if you do it unilaterally also, you can still
But the woman can still claim maintenance.
So and a child out of live-in relationship
to be called legitimate.
Yeah. So that's another thing.
Yeah. So in this case, two persons living in together. People can live in together for a week, 2 weeks, 6 weeks, right? They can have a relationship for 6 weeks, 8 weeks, 10 weeks. At which point does somebody or the state come to the finding that this is a live-in relationship requiring registration?
So that's exactly what Apoorva has pointed out. All the duration is not specified, but I just add to this that the couple needs to inform the registrar within a month. So suppose they've been staying together for a month, they have to then go to the authority concerned and file a form, whichever form is going to be released by the state. They have to file a form, given information. In case they don't do that, then there is a penalty as well as jail term. And if the registrar or the sub-registrar gets to know about a live-in relationship, then that couple can be issued a notice by the sub-registrar to which the couple has to respond. In case they fail to do so, that is also punishable and becomes a crime.
And that's an increased punishment.
Yeah, that's an increased punishment.
And suppose they said, we are just friends.
Or living as roommates. That's
what I meant.
Exactly. So that definition is not there. That is an ambiguity in the law. There is a gap in that. And but then the concern is the inquiry.
Yeah, I was just about to
a registrar can initiate an inquiry also.
So tell us about the inquiry.
So just to add to what Bhadra said, any couple who intends to be in a live-in relationship within a month has to inform the registrar. If they fail to inform the registrar, they can be served a notice, which will also include a fine as well as an imprisonment, which can be up to 3 months. If they are served a notice and they fail to respond to that notice, then they can be imprisoned for a period of 6 months. At the same time, if they do reach out to the registrar for registering the live-in relationship, the registrar can get into the verification process. He can even call whosoever he wishes to, for instance, a neighbor also.
Yeah, but in this case, this is also open season for neighbors, for landlords, and
noisy,
or anybody, even a street vendor to say, I have heard so and so are living together, right? And to bring police into people's homes.
Yes.
So
that is what the opposition has been
politically, I find this interesting because these are not part of the ideological mix from which the RSS had come at Uniform Civil Code. That was more about marriage, how many spouses, how many marriages, etc., etc. It wasn't so much about this morality. Now it looks like that politically, I'm saying this, not these three. There is an effort by the BJP also to appeal to the older generation's sense of morality. Because older generations are not happy to see their children living together. They'd rather have them properly married and then have janam ka saath after that, which doesn't always happen. So in this case, this looks like something that this is an appeal to conservatism as I see it. A lot of the younger people will not like it and many of them are protesting. But I think politically BJP's impression would be that these are really the urban, well-to-do, quote-unquote, woke people. And BJP right now, BJP as well as the RSS, they have a war on wokedom and this may be a part of that.
And just to add to that, when they were drafting this bill, I had spoken to a few of the members and they had pointed out that during consultation, it is from there they got the hint that they should include live-in relationship in the Uniform Civil Code.
So basically the uncles and the aunties have got into the act now. That is the reality. And this, Bhadra, you think can be challenged in Supreme Court?
Yes, of course. And I think apart from this, what another area of concern which I felt after reading the code is with regard to the maintenance of a register where the marriages will be registered, and in fact even the live-in relationships will be registered. So now that particular register can be actually shown to anybody, in the sense it is open for public use, subject to the person who wants to see it paying some amount of a fee that would be decided. So that again is, I think, is likely to affect the right of privacy of the people, because how can you actually make all this information public? Whether who is registering the marriage, who is registering the live-in relationship, that ideally should be a very private affair. You can't make it a public affair. So which means tomorrow anybody, any third party can just walk up to the authority and say, I'm willing to pay a fee. I want to see the register because I'm probably, a detective hired by so-and-so to look into the background or to conduct a background check about so-and-so. So this is again, I think, a major area of concern for the younger generation.
So this is really becoming like a guardian state, because you might be 19, a man and a woman, or a couple, maybe 19 and a half, 20 and a half years old.
Yes.
And yet the state will have the right, or in this case the duty, to inform their parents. Right? So this is really taking you in a direction where people who are doing it know what they are doing. Right. And I can see politically, Neelam, you think that this will appeal to the older generation?
It definitely will, because as far as Uttarakhand is concerned, I had spoken to a lot of people and they had said that, they had received many complaints from RWAs that this live-in culture is at its peak. And they have to ensure, and they talked about women rights and women empowerment, and they said that to ensure that nothing, happens to women in terms of if they enter into a live-in relationship and there are no safeguards, how do you ensure that a woman is safe? So they had taken that plea, but I'm sure that,
everybody is a guardian of
women's
the women,
morality.
particularly in India. In fact, on that note, I will also mention to you that a long time back, although it was later held illegal and was banned, Gujarat had a system of what was called as Maitri Karar. And Maitri Karar was like a non-marriage marriage, bit like a live-in relationship, although that is something that was used or misused by married men to have relationships outside of marriage, so they couldn't marry the other woman, so they'll just sign a contract, and that was called Maitri Karar. So maybe about 30 years back, when I used to work at India Today, we ran a story in India Today about this. I noticed subsequently that this was banned. So this is becoming, for younger people, a kind of a Maitri Karar. So a live-in relationship for 35 days becomes a legally sustainable arrangement, which will lead to claims of maintenance, etc., and then there'll be paternity suits, for all you know.
And a lot of people are saying, why not get married then, if you have to go through all of this? And they're saying this will result in more divorces, because with a live-in relationship, you are able to be in that relationship and then decide whether you want to take it forward or not.
Right.
Yes. Another important thing that we have not mentioned is that the scheduled tribe, the tribal population, has been kept out of the ambit of the Uniform Civil Code. So they can follow their own customs and rules.
Yeah. So for example, this one says no polygamy and no polyandry. So it's interesting that keep the tribes out of this, because the only part of India's population where you still might find some polyandry, or at least where there's been tradition of polyandry, are the tribes of Kinnaur in Himachal Pradesh, in the highest reaches of Himachal Pradesh. And the story goes that that's the route the Pandavas took when they're going, when they are ascending up to heaven. And because Draupadi had 5 husbands, so they were an example of polyandry, and that's how the tribes there acquired the culture. So in fact, I had mentioned this in one of the earlier episodes also, that Dr. Yashwant Singh Parmar, who was Chief Minister of Himachal Pradesh, he was doctor because he had a genuine PhD, and his PhD was on polyandry in Himachal Pradesh. So in any case, I don't think this persists there anymore, but at the same time, the tribes are exempted. That said, Apoorva, will you tell us what are these prohibited relationships?
So Shekhar, prohibited relationships are essentially relationships that two people share where they cannot marry. For example, basic example being that a child, like a son or a daughter, cannot marry a parent. So there's degrees of prohibited relationship, a list that is given, and that's always been there. Hindu Marriage Act also talks about prohibited relationships, and that's what siblings cannot marry, you can't marry your stepmother or son's widow or daughter's daughter, son's daughter. So there's a long list of relationships that you cannot marry, and that's been reproduced here and applied uniformly to all.
But has it been expanded? Because in many communities, say cousins can marry, and that doesn't just apply, say, to Muslims or any faith. That happens among many ethnicities, among Hindus as well.
So it's interesting what this says. This provision says that under conditions for marriage, it says conditions should be fulfilled. One condition is parties are not within degrees of prohibited relationship unless custom or usage governing one of them permits marriage between the two. Now, this provision was always there in Hindu Marriage Act as well, with this exception. Now, another exception has been added, that such custom and usage should not be against public policy or morality too, which is another area of ambiguity from what I understand, because public policy and morality are very ambiguous.
So what is public policy and morality in this one?
Again, it is not defined.
It's not defined.
It's silent. The law is silent on it. So again, it will be subject to interpretation. It could be subject to interpretation of the court where the case may go, or it could be subject to the interpretation of the
the
we
rules
also
might
have to
also
see what the rules are going to say.
So usage and custom still prevails. It says that it shouldn't be a prohibited relationship unless there's usage or custom. But even there, it shouldn't be against public policy and morality, which haven't been defined. So
public policy and morality is once again striking a blow for conservatism, for social conservatism, right? That stray in one narrow, on one narrow path, narrow and correct, quote unquote, moral path. And this might, Neelam, you think this will find some wider support? Particularly from older generation?
Well, definitely, as far as, I mean, if I give an example of Uttarakhand, when it decided to form a committee and go for UCC, this happened in 2022 February, just before elections in Uttar Pradesh and Uttarakhand and other state assemblies. And at that time, Pushkar Singh Dhami, who was the chief minister at that time also, had said that this will ensure that, same set of rules and laws are in place. And this happened when when this entire controversy had broken out in Karnataka about the hijab. And BJP's General Secretary organization, B.L. Santosh, had said that, just as...
He's from the RSS.
He's from the RSS.
Everybody's from the RSS, but he's the RSS...
Correct.
The RSS person in the BJP.
In the BJP. And so why I'm pointing it out is that, they are all linked. While Dhami announcing this, that we will do this, it is a neighboring state of Uttar Pradesh where elections were to be held. And this was going on simultaneously when there was this demand for a hijab ban in Karnataka. And at that point itself, B.L. Santosh, who is BJP's General Secretary organization, had posted Dhami's statement on social media platform X. And at the same time, Uttar Pradesh BJP chief at that time, Swatantra Dev Singh, had said that just as in the case of removal of Article 370, which dealt with special status for Kashmir, and enactment of the Triple Talaq and the Citizenship Amendment Act, BJP would also fulfill its promise of UCC. Giriraj Singh had also at that point pointed out that, the time has come for the nation to have a uniform civil code. And then at the same time, why it becomes important right now is because many private bills have been moved in the parliament, especially by a number of BJP parliamentarians. This has become sort of a testing ground for the BJP, whether to push for it at the national level or not. And also it comes at a time before the 2024 elections. They can definitely make it a poll issue, especially other states like Madhya Pradesh, Uttar Pradesh, Assam, Gujarat.
They're all talking about
this. They're already talking about it. Himachal Pradesh, they are no longer in government, where they had also promised to bring in. And Uttar Pradesh becomes all the more important because, it sends 80 parliamentarians to the parliament. So I feel that, Article 370 has been fulfilled, Ram Mandir has been constructed. So this is the third main poll promise or the manifesto promise of the BJP, which it now wants to fulfill. And even if it is not able to do it at the national level, it is telling the people that we have done it in this state, that intent is there. And if you vote us again to power, this is something that we will definitely do. And this is also a promise. This is also a promise of the RSS.
Now, there's also one more very interesting provision. And Bhadra, I will ask you to explain this, which says that a man can marry a woman who he may have divorced. Now, you would have thought, okay, you didn't get together, you didn't get along, you divorced. After a while, you missed each other, you got married, decided to get married again. So this is then sort of addressing the Islamic practice that if a man and a woman divorce, they cannot remarry unless the woman has married someone else.
Yes, that's right.
Again.
Yeah, so this practice is called the nikah halala practice, which is prevalent in the in the Muslim community, and it's been quite a contentious topic as well. Basically, in this practice, a woman who divorces her husband, and if they want to remarry, then the woman has to marry another man, divorce him, and then come back to marry the first husband. So now UCC has very categorically said that this kind of condition should not be there in case a woman who is divorced from the first husband wants to remarry him. In fact, it goes a step ahead. It criminalizes, it actually treats any person as a criminal who forces the woman to carry on with the practice of nikah halala. So it has completely eliminated that practice now. And it has implemented the uniform practice, which was earlier in practice in the Hindu community under the Hindu Marriage Act. The same practice is now applicable even to the Muslim women. So this has been an area of concern in the sense that there are some petitions also filed in the Supreme Court challenging this practice. So let's see how those petitions now would be heard in the Supreme Court.
This in fact makes a lot, if it's passed or on the national level, we'll have to see, because a lot of Supreme Court petitions are on halala, polygamy as well. They're all pending right now in the court.
Yeah, but once these laws come up everywhere and national laws come in, law comes in, then that will be tested in Supreme Court.
Yes.
Now, Apoorva, this new law also says interesting things about succession. Just explain those to me.
Right. I will try to make it as simple as possible.
That's the idea. That's why we call this. That's why we call this Cut The Clutter.
Yes, quite complicated. So I won't go into many details. But essentially, under the Hindu Succession Act, we used to have classes of heirs on whom interstate succession can happen. Interstate meaning that there isn't a will. So how will the property pass on to the heirs? Now, there used to be class 1, class 2 heirs. Muslim personal law was different, as were other personal laws. Now, this uniformly talks about class 1, class 2 heirs for all the communities. And within that, it gives equal rights to the male as well as female heirs as far as succession is concerned. There's another thing, and that was a discrimination within the Hindu law, and that was a concern that was given before that. Under the Hindu law currently, there are different ways on which, for dealing with properties of males and females, when a male or a female passes away. So essentially meaning that Hindu succession law gives priority to the husband's family over the woman's parents and siblings when it comes to a woman's self-acquired property if she dies without a will. This was considered discriminatory earlier. Now, this code has made the same provisions. When a man or a woman dies, their property devolves to their heirs in a similar manner.
So the families of both have the same are on the
priority,
same are on the same footing.
Right. Yeah. So that's about succession largely.
So is there any other point that we are overlooking, Bhadra?
So I would like to add one point over here, which is with regard to the maintenance. Now, this code has introduced a very interesting feature in the maintenance provision, and that says that if anybody is married before the code commences or comes into notification, and if that person, say, has more than one wife, 2 or 3 wives, those wives can also go to the court now and seek for maintenance. Now, those wives could be anybody under any community. So I think that is very important because, as of now, the other laws do not talk about how to deal with extra wives, particularly the Islamic law. It's quiet on maintenance and alimony of more than one wife, which is now taken care of in this new code.
Now we are coming close to the conclusion of this analysis. So Neelam, why has the BJP been so careful to keep the tribals out of the ambit of this change?
Right. So, there are 47 seats in the Lok Sabha which are reserved for the scheduled tribe community. At the same time, Law Commission had also invited suggestions from people across the country on the Uniform Civil Code, which would be for the country. At that time itself, Vanvasi Kalyan Ashram, which is affiliated to the RSS, had also said that please keep tribals out of the ambit of the proposed Uniform Civil Code. So the tribal community as a vote bank is very important for the BJP. We have been witnessing how BJP has come up with certain welfare measures, especially for the community. So at this juncture, they would not want to, come up with anything that can dent their image of being pro-tribals. And at the same time, whatever is happening in Jharkhand right now, where you have a tribal chief minister who has accused the center of hatching a conspiracy to remove him, at that point it becomes all the more integral that BJP doesn't appear as anti-tribals.
Yeah, so remember 8% of India is tribal, which would make about the tribal population in India at about 11 crores. It's by far the largest tribal population in the world. And there's one little nuance there, that when earlier some communities, particularly Muslims, had followed their own personal laws, that's when people could convert and get married a second time, etc. And some famous people have done that also. So you can convert and become a follower of another faith, but you cannot convert any which way and become a tribal. You can change your religion, but you cannot change your ethnicity. So those are the basic big pointers from this. This one state government has done it. It doesn't mean it's an isolated act. This is a trial balloon which has now become a reality in the state. And usually you would presume that other BJP states will do it, and that will cause the Congress party and other parties a dilemma. At the same time, you might see that in Karnataka, for example, if the Congress party is in power and they don't do this, then it will become a magnet for the younger professionals who don't yet want to commit, but they still want to live together. So this is where I think some bit of competition will come in. So in America, we know different states have different rules for divorce, for abortion also. You can be denied in one, go to the other. Can India also be headed for a situation like that? So first of all, Bhadra, yes or no?
Yes, of course. India, different states in India can have their own personal laws, and that is allowed under List 3, which actually deals with concrete list subjects. So entry 5 in this particular list deals with marriage, inheritance, succession, and of course divorce. So under this entry, any state government can make its own state laws. In fact, I would just like to recollect the recent Supreme Court judgment in the same-sex marriage, where a constitution bench of the Supreme Court actually said that if the state governments want, they can bring about changes in their laws to recognize same-sex marriages. So yes, states can do it. However, if there is any central government law which covers this area and is repugnant, and the state law is repugnant to that central law, then the central law comes into effect. However, till then, the state law...
So central law will then supersede this?
Yes, central law supersedes.
Apoorva, if this is challenged in Supreme Court, what is it that you will see as most challengeable, and that in your view is most likely to be struck down, if at all?
I can only speculate, but like we mentioned before, I think it is the live-in relationship bit, because again, privacy would be an argument that would be given for it. It also criminalizes not notifying, not giving a statement for live-in relationships. There's also ambiguity in the provision, which again, provisions can be struck down, or if they are ambiguous because doesn't even define what a live-in relationship is. Then there's conflicting provisions with I'm just making a summary out of all the contentious provisions, but the ambiguity with regard to the age and age of majority being 18. Forget age of marriage also. If age of majority is 18, courts have said with regard to people seeking protections, people who are in a live-in relationship, when they go to the court for protection, courts have said again and again, once you attain the age of majority, you can vote.
And you
can live with whoever you want.
Right to choice, basically.
Right to choose your partner.
The minute you turn 18, your right to choice comes into effect.
So this then goes against those orders and judgments as well, because if you're informing the parents or guardians unless you turn 21, that could be a plank for challenge, of course. So I think live-in relationship, that entire part could end up in courts.
And Neelam, you see the BJP pushing this, and how do you see the opposition responding now?
Well, to begin with, the BJP in Uttarakhand has already decided that they will be holding thank you procession, sweets will be distributed, and they are already going to talk about how we have done it in Uttarakhand and other states will follow. As far as the opposition is concerned, as we have already discussed, apart from the privacy aspect, they really don't have much to criticize because it talks about empowerment of women and giving rights to women, something which they will not officially, or at least on the face of it, they will not be able to challenge or criticize.
Well, all I would say in conclusion is that most of it is as expected, because a lot of it is directed at the special provisions that the Muslim personal law had. So this was expected. Some of these have been talked about: polygamy, triple talaq, etc., etc. The interesting thing is, and the surprise to me is, that this has come with the tadka of social conservatism, which is essentially the attack on live-in relationships. And that makes it a very interesting proposition, because globally in democracy there is a debate, there is polarization between socially liberal parties and also socially conservative parties, as in the US on the divorce issue, for example. Now, is such a thing going to develop in India? The fact is, in Indian politics, we haven't really had many major national political parties who've taken the position of social liberalism when it comes to personal relationships.